91-year-old Mashilo Masemola, a former struggle veteran and legal practitioner in the late 1990s, was convicted of fraud and sentenced to 5 years in prison in 2001. As a result, his pension was revoked. He was later pardoned by then-President Jacob Zuma in 2011 and has since been fighting through the courts to get his pension reinstated.
At the time of his pardon on 21 July 2011, did Mr. Masemola automatically requalify for his pension benefit under operation of the law, or would he have had to reapply afresh?
We would submit that his right was established at the time that he applied in 1997. In 1997, he applied, he qualified under Section 1 of the statute, his application was approved, and he was paid the special pension. If he didn't receive a pardon, it would have rendered him fully ineligible for all time. But the effect of the pardon was to render that ineligibility temporary. So once the pardon was granted, his ineligibility ceased to exist.
Lawyers for the Pensions Agency argued that Masemola forfeited his pension as a struggle veteran once he was convicted.
Let us assume, and it's an assumption, it's for argument's sake, that it was still open for Mr. Masemola to apply for this benefit after the obliteration of the offending act through a presidential pardon. Would you argue that he wouldn't qualify?
We're saying whatever you are going to make of those facts must be disclosed in the form. To say I was convicted, I received presidential pardon. Then what the functionary is going to draw from that is a legal conclusion.
Would stating that fact on oath lead to a different conclusion at all?
It would lead to the same outcome, in the sense that he would then be granted the special pension if the special pension is available at that time.
The matter has been reserved for judgment. Nozintombi Mia, SABC News, Johannesburg.